Hey everyone, it's Laura from TheRealLauraB here on YouTube and Twitter, and I'm back today with Johnny Depp's Court of Appeals brief. I know it's been covered. It dropped when I was traveling. I was literally in the security line to go through to get into the airport. It dropped. I got my email. I shared it with a lot of people who have reported on it. So I wasn't going to do a video, but then I felt like there was a hole in my YouTube account if I didn't have this memorialized. So that's what I'm going to be bringing today. And so let's get started.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
So I'm excited to bring this today. I've had a chance to watch a lot of LawTubers present their side of it, and it sounds like they all believe Johnny has a really good chance on this. So why don't we jump into it? I'm not going to read every bit of it. Let me zoom in. I love his font in the beginning. Now, some people said that the Court of Appeal, they're very particular about the number of characters in a brief and the typeface that they have to use, the font. So I thought that was interesting. I don't know whether this is required or whether that's just something they decided to be fancy about. So they have the table of authorities, of course, the statement of the case. We're going to go down and skip all of this and get right into the meat of it. These are all the cases they're citing. No, I'm going to drive you crazy scrolling. The rules of conduct. The statement of the case. Yeah, I think we know what the statement of the case is because we've already covered his assignment of errors, which are only 3. So let's start with the introduction. The jury's emphatic, favorable verdict on all 3 defamatory statements alleged in his complaint fully vindicated Mr. Depp and restored his reputation. Indeed, Mr. Depp prevailed in the trial court on virtually all material issues, and the verdict of the jury and the judgment of the trial court represent an intelligent and well-reasoned decision on the merits after a full and fair trial should be largely, though not entirely, affirmed. However, the trial court was confronted with a number of novel and complex legal and factual issues, and although the trial court decided the vast majority of those issues sensibly and correctly, a few rulings were erroneous. And I think that's a great start off right from the get-go because they've got their brief before Amber Heard's brief. They're reading this. Sometimes they'll have a hearing. Sometimes they may just decide on the paperwork. But he's pretty much setting the stage right now. Look, Mr. Depp won on almost everything except for one statement. And it's based on, and they'll get into that, but it's mostly, having Mr. Waldman be his agent and not an independent contractor. So I love that they're telling the judges right off, look, he prevailed on everything. The jury found everything. It was just a little confusing because of these rulings. Mr. Depp does not appeal the verdict on his claim, nor does he appeal the verdict in his favor on 2 of the 3 Waldman statements. His appeal relates solely to the Waldman statement on which Ms. Heard prevailed, a statement in a Daily Mail article dated April 27, 2020. The judgment in Ms. Heard's favor on that lone statement is erroneous. Ms. Heard's claim was fatally flawed, and the trial court should have granted Mr. Depp's motion for summary judgment and his motion to strike the evidence for 3 reasons. First, Mr. Depp cannot be held liable for Mr. Waldman's statements as a matter of law. Ms. Heard sought to hold Mr. Depp liable for the April 27th Waldman statement on pure theory of vicarious liability, contending that Mr. Depp was liable merely because Mr. Waldman had been retained by Mr. Depp as his attorney and was therefore his agent. But a matter of law, Mr. Waldman is an independent contractor whose allegedly tortuous conduct is not automatically attributable to Mr. Depp. Indeed, a wealth of authorities support limiting a client's liability for allegedly torturous conduct by an attorney, and the court should impose the same limit here. Second, because Ms. Heard proceeded against Mr. Depp at trial on a purely vicarious theory of liability, she was required to present evidence that Mr. Waldman committed each element of the tort of defamation, including that he acted with actual malice. No evidence of Mr. Waldman's actual malice was presented at trial, so the judgment against Mr. Depp cannot be sustained. Third, the April 27 Waldman statement, viewed in context, is a non-actionable statement of opinion insufficient to support a claim for defamation. In addition to erroneously denying Mr. Depp's motion for summary judgment and motion to strike, the trial court also erred in 1, excluding from evidence the complete Daily Mail articles containing the Waldman statements, and 2, refusing to give jury instructions as to Mr. Waldman's status as an independent contractor. So we have the assignments of error. We know what they are. They pretty much just reintroduced them. So let's go to the statement of facts. The Waldman statements, in connection with her counterclaim, Ms. Heard contended at trial that Mr. Waldman, acting as Mr. Depp's agent, defamed her in 3 statements to the United Kingdom tabloid, the Daily Mail. The first Waldman statement was quoted in a Daily Mail article dated April 8, 2020, and stated that Ms. Heard had used fake SV allegations and promoted SV hoax as facts. The article also contained a general discussion of the dispute and litigation between Mr. Depp and Ms. Heard, and quotes from attorneys adverse to Mr. Depp. The jury did not find this statement to be defamatory. The second Waldman statement was quoted in a June 24, 2020 Daily Mail, and stated that Ms. Heard's allegations were a hoax. And that's important that the word hoax is being used in all 3 statements, and yet they found for Johnny on 2 of the hoax statements. The article also included a quote from Ms. Heard's attorney that we believe Amber and we believe in Amber. And these designations are where they can find them in the court transcripts, etc., whatever the exhibits they're providing to support this. This is for easy reference for the appeal judges. And a summary of both Mr. Depp's and Ms. Heard's side of the dispute. The jury did not find this statement to be defamatory either. The April 27th Waldman statement, the sole statement on which the jury found in Ms. Heard's favor, is contained in Daily Mail article dated April 27, 2020, with the headline, "Exclusive. I need to report an assault. Listen to 911 call made the night Johnny Depp and Amber Heard had blowout fight that ended their toxic 18-month marriage, but both claim tape backs up their version of events." That's the title of the article. The April 27th article describes a recording of a phone call to the police on the night of May 21st, 2016, a date on which Ms. Heard alleged Mr. Depp threw a phone at her and roughed up the apartment at the Eastern Columbia building. Back to that article. The article noted, for instance, Ms. Heard's lurid 300-page filing cataloging the horrific abuse she claims to have suffered at Mr. Depp's hands. It's interesting they're putting this, they're referencing it, all the claims she made, but remember, they've opened this article up that the jury found she was liable. The jury unanimously found that she had lied. So it's interesting that they're making sure they look at this 300-page filing of all her allegations that the jury said, didn't happen. The April 27th article comments that Heard's attorney says phone records and police department logs vindicate Heard's account of the final shocking episode of DV she endured before filing for divorce, whereas Depp's legal team say this recording does the precise opposite. However, by raising discrepancies in the various accounts Heard and her allies had given of the notorious dust-up. Now, the jury didn't get to see this part of the article. It details Ms. Heard's various allegations about the abuse she claims to have suffered on May 21, 2016, noting that, quote, "The DV case ultimately fizzled when the 2 LAPD officers who responded to the 8:27 p.m. call, Melissa Sands and Tyler Haddon, said they never found any evidence of a crime." And the jury didn't get to see that part of the article. The April 27th article further states that Depp's lawyer, Adam Waldman, said the various discrepancies proved that nothing Heard and her friends said about the events of May 21, 2016 could be considered credible. It sets out Mr. Waldman's purportedly defamatory statement. So again, the jury didn't get to see that part of the article. They only got to see this very detailed quote. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops. But the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their stories straight under the direction of a lawyer and publicist, and then placed a second call to 911. This was quite detailed, and I think that's what the jury had a problem with. It also doesn't appear to be couched as an opinion without the follow-up of the rest of the story. It sounds like, quite simply, this was almost like a statement of fact. But Waldman's prior statements earlier said it's got lots of discrepancies that could lead you to making this an opinion. We'll see. It also was very detailed here, which may have been what the jury didn't like. Under the direction of a lawyer and publicist. I don't know that that was proven. Anyway, the April 27th article also includes quotes from Mr. Waldman that Ms. Heard did not include in her defamation claim. But even this didn't have the desired effect because two DA-trained LAPD police would later provide a pair of sworn depositions saying they saw no evidence of a crime. These lies about who made the calls and when are just the tip of the iceberg, as the evidence will show in court. Again, the jury didn't know anything about those quotes. Finally, it presents a contrary view, quoting Ms. Heard's attorney at the time. Heard's legal team rejected those allegations as fantasies. Mr. Depp's representations about the 9/11 calls on the night, May 21, are false, and Mr. Depp and his lawyers should know better, said her attorney, Roberta Kaplan. All of the evidence, including sworn testimony from multiple witnesses, phone records, and police department logs, are consistent with the truthful account given by a witness favorable to Ms. Heard. So, again, the jury didn't get to see that both lawyers were commenting in this article. Both lawyers were stating what fact, opinion based on the evidence that they wanted to present. Evidence relating to Waldman's statements at trial. So this is the second claim. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making any of the three Waldman statements. Indeed, Mr. Depp testified that he had never seen the Waldman statements prior to the filing of the counterclaim in August 2020, and they're providing the reference to his testimony transcript. Mr. Waldman has a professional license, is the owner and managing member of his own law firm, and provides legal services to his clients. That's an important thing because if you think about some big companies that maybe get sued, they have their own internal legal department. So if one of those lawyers gave a statement, they're employed by the company itself. So they would be an agent of that company that's being sued. Mr. Waldman has his own agency, his own professional law firm. He's not an in-house lawyer to Mr. Depp. In fact, Mr. Depp uses more than one lawyer, and those lawyers are not even all part of Mr. Waldman's firm. So there's no in-house counsel for Mr. Depp. So that would feed into the idea that he is an independent contractor and not an employee of Johnny's, making him an agent. Mr. Waldman was retained by Mr. Depp in October 2016 and still represented Mr. Depp at the time of his trial testimony, but Mr. Depp is not his only client. Mr. Waldman's relationship with Mr. Depp is solely one of attorney-client and has represented Mr. Depp in various litigation matters, including his litigation against Ms. Heard. Mr. Waldman testified that while he believed he had some knowledge of the conduct of Mr. Depp and Ms. Heard, he never personally witnessed any interactions between them prior to his retention in October of 2016, which was after their separation. So if he had no knowledge of their relationship, where is he getting this information for quotes? And it's from the evidence that he helped collect. Mr. Waldman testified that he made each of the Waldman statements. Ms. Heard did not present any evidence as to whether or why Mr. Waldman believed each of these specific statements. In response to a more general inquiry about Ms. Heard's allegations, however, Mr. Waldman testified at length on why he believed that Ms. Heard's allegations against Mr. Depp were false, describing physical evidence and identifying multiple witnesses whose testimony he believed contradicted her allegations. Mr. Waldman also testified that he had filed a claim with the Los Angeles Police Department against Ms. Heard for perjury due to her claims that Mr. Depp abused her, and that he presented them with information that established her perjury. So all this is couching that he completely believed in Mr. Depp, so therefore his statements were not made with malice. They were not made knowing they were false, because he believed with all the evidence he collected and that he actually filed a complaint that he believed Ms. Heard lied. Here's the argument. The trial court erred in denying Mr. Depp's motion for summary judgment, motion to strike the evidence, standard review. In reviewing a ruling on a motion for summary judgment, a motion to strike, the court normally considers the relevant portions of the record in the light most favorable to the non-moving party, which is Ms. Heard, and draws reasonable inferences in favor of the non-moving party. However, an appellate court in Virginia on the issue of punitive damages, or where actual malice must be proven, must independently decide whether the evidence in the record on appeal is sufficient to support a finding of the New York Times actual malice by clear and convincing proof. So they're they're laying their basis for their cases that they're using. In addition, questions of law are subject to de novo review. Whether an allegedly defamatory statement is an actionable statement of fact or non-actionable opinion is a matter of law to be determined by the court and is reviewed de novo. Under most circumstances, whether a person is an employee or an independent contractor is generally a question of fact for the jury. But whereas here the evidence admits of only one conclusion, the question is a matter of law that is reviewed de novo. Well, let's look up that word. De novo. From the beginning or anew. A general strategy is de novo protein design, but let's see what else it means. It's a Latin term that means anew or from the beginning or fresh. When a court hears a case de novo, it is deciding the issues without reference to any legal conclusion or assumption made by the previous court to hear the case. So they're basically saying you need to look at this with fresh eyes, not just how Judge Ascarati or the jury decided. But is this really how Judge Ascarati should have defined this? Mr. Waldman's an independent contractor. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making the Waldman statements. Instead, she chose to pursue a pure vicarious liability claim against Mr. Depp, contending that he was liable for Mr. Waldman's allegedly defamatory statements simply because he was his attorney. Ms. Heard's proposed jury instructions on her counterclaim, which the trial court adopted and gave to the jury, were based solely on vicarious liability theory and did not require a finding of any conduct by Mr. Depp in connection with the statements. That claim fails on a threshold issue, whether as a matter of law, Mr. Depp can be held liable for an intentional tort of defamation based solely on statements made by his attorney on a pure agency theory. In the context of vicarious liability, Virginia has long recognized the distinction between servants, that's the old word I'm hearing, meaning employees, that's the old legal word, servants, employees, and independent contractors, and follows the well-established rule that a principal is generally not liable for the tortious conduct of an independent contractor. Recognizing that in Virginia, the doctrine of respondeat superior imposes tort liability on an employer for the negligent acts of its employees and its servants, but not for the negligent acts of an independent contractor. And declining to adopt an exception to this rule for the tortious actions of an independent contractor who was ostensibly an apparent agent. The theory on which the master is liable for his servant's conduct is based on the right of the master, actual or potential, to control the conduct and to see to it that the negligent acts which cause the injuries to others do not occur. So this is what they're citing from 1940. So think about this. If a truck driver for a company, where the company owns the trucks, the company's responsible for maintaining the trucks, the company's apparently responsible for making sure its drivers are licensed, etc., gets into an accident, the employer would be sued. And when you're hurt, you're going to go to the level of the person who has the most money to help you. That driver may not have a lot of money. If you've been hurt, you want to go to the highest level you can. The trucks are owned by the employee, the company. The employee was doing the company's bidding at the time. So that's acting as an agent. That's an employee of the company. If the relation between them does not give the employer that power, then he should not be held responsible for any occurrence over which he had no control. In assessing whether a person is an independent contractor, courts consider 4 factors: selection and engagement, payment of compensation, power of dismissal, and power to control the work of the individual. The 4th factor, the power to control, is determinative. Well, Johnny did hire him. He did pay him. He didn't give him a W-2. He didn't pay his taxes. He just paid him the fee that he was billed for. The power of dismissal, yes, Johnny could dismiss him. But Johnny's not a lawyer. He couldn't tell Adam how to write word for word all his motions. He could ask Adam to do certain things, and Adam as a lawyer would say, gee, that's not legal for me to do. I'm not allowed to do that. So he had control over his own decisions in what he could do as a lawyer, more so than Johnny did. Mr. Depp has not been able to identify any Virginia Supreme Court authority squarely considering the specific issues of, one, whether an attorney retained in connection with litigation is an independent contractor, and two, whether the principal limiting liability for conduct of an independent contractor applies in the principal agent context, specifically with respect to the attorney-client relationship. Notably, the Virginia Supreme Court has cited with apparent approval the restatements approach, which limits liability of a principal for the actions of a non-servant agent. However, and I remember Camille giving, when she was asked about the appeal, she's in an interview, she said, we couldn't find a lot of law on the subject in Virginia. However, although other jurisdictions are not uniform, the majority rule, and the rule that should be adopted by the court, is that an attorney retained by a client for litigation, though undoubtedly an agent of the client in the litigation, nonetheless stands in the capacity of a non-servant agent, an independent contractor, and therefore the client is generally not vicariously liable for the lawyer's misconduct, absent exceptions to the general rule that are not present here. Although the authorities are not unanimous, most other jurisdictions that have considered the issue have concluded that attorneys retained in litigation act as independent contractors, and those jurisdictions have accordingly imposed limits on clients' liability for torturous acts by their attorneys. So there are finding cases outside of Virginia. The weight of authority provides that a client generally is not vicariously liable for its attorney's torts, absent evidence that the client directed, controlled, authorized, or ratified the attorney's allegedly torturous conduct. A law firm attorney working with a client is nonetheless an independent contractor and not an employee of the client corporation. So this is a Virginia case. Independent counsel retained to conduct litigation. The court acts in the capacity of an independent contractor. So they're finding case law on this. Under traditional master-servant, and this would be, I think, Georgia, under traditional master-servant law, the attorney was an independent contractor. We think the unique attorney-client relationship should not be analyzed merely with reference to ordinary agency law. A general retention of an attorney to do all things necessary to pursue a claim or defense should, in legal contemplation, mean that the attorney has authority to do all things legal and proper, not otherwise. We will not presume a direction or authority or permission to commit a torturous or legal act inheres in the usual attorney-client relationship. So if Johnny were to order Adam to do something illegally, Adam could say no. When, as here, an attorney acts pursuant to the exercise of independent professional judgment, he or she acts presumptively as an independent contractor whose intentional misconduct may generally not be imputed to the client. So they're finding a lot of law on it. I don't know what state this was from. Here's one from New Jersey. There's a vast difference between an employee agent and a non-employee agent. The non-employee agent is generally nothing else but an independent contractor. Attorneys generally are not subject to their client's actual control or direction. It's New York. Treating law firm retained by insurance company as independent contractor. So they're finding a lot of case law outside that lawyers are always an independent contractor whose negligence, if any, is not imputed to the insurance company that retained it. The mere fact that an agency relationship existed between the client appellees and the attorney appellees does not mean that the client appellees would automatically be liable for any torturous conduct, unless a client is implicated in some way other than merely being represented by the attorney alleged to have committed the intentional wrongful conduct. The client cannot be held liable for the attorney's conduct. Now, you remember the questioning with Adam. The lawyers kept saying, did Johnny instruct you? And he had to claim privilege because that's what he's required to do. And a lot of the law tubers said that was very wrong, that the jury got to hear question after question after question with the same answer. When Ben Chu says we ask him to not to answer based on client-attorney privilege, and Adam says, I accept that direction. So even though in the jury instructions they were told, do not take that inference of liable or not, that the attorney refused to answer, that's his right. But to hear it over and over again, yet Johnny himself testified that he didn't know anything about these statements until he was sued for them. There are sound reasons why multiple jurisdictions have concluded that vicarious liability should have a limited application in the context of the attorney-client relationship. Lawyers, as legal professionals, typically are not subject to their clients' control with respect to the manner in which they provide their services. If clients cannot control the details of their attorney's work, it makes little sense that clients should nonetheless be held accountable for their attorney's torturous acts. Attorneys generally are not subject to their clients' actual control or directions. Indeed, most clients have an attorney because they are unfamiliar with the law and want an attorney to guide them through the intricacies of that field. As professionals, attorneys are deemed responsible for their own acts, and in this case, most clients have legal recourse against the attorney and his law firm for their actions. Although a lawyer is subject to the client's direction with respect to the goal of the representation, it is the lawyer who has wide discretion as to the means by which those goals are achieved. In every American jurisdiction, including Virginia, a lawyer is required to exercise independent professional judgment and is subject to independent professional and ethical obligations. That's in the rules of conduct. And you saw in their first few pages where they gave their, I call them table of contents, they cited many Virginia rules of professional conduct. A lawyer shall abide by a client's decisions concerning the objectives of representations and shall consult with the client as to the means by which they are to be pursued. And in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. Further, a lawyer is prohibited from advancing frivolous arguments on behalf of a client. And a lawyer has a duty of candor to the court and is permitted to refuse to present evidence on behalf of a client that the lawyer reasonably believes is false. A lawyer is, in sum, required to exercise professional expertise beyond that of the typical client. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and a preparation reasonably necessary for the representation. There are accordingly substantial limitations on the client's ability to control the activities of the lawyer. In any case, the typical client who generally lacks legal expertise cannot monitor the conduct of a lawyer for wrongful activity. As a client's agent, the lawyer's conduct may be binding on the client with respect to positions taken in litigation or in a business transaction, but to hold the client liable for an attorney's intentional tort goes a step too far and is fundamentally inconsistent with the logic behind independent contractor principles of limited liabilities. Here, the evidence established that Mr. Waldman was retained by Mr. Depp to act as attorney, and that he acted in that capacity in several litigation matters, including the initial stages of Mr. Depp's litigation against Ms. Heard. Other facts that underline Mr. Waldman's role as an independent contractor only are that he is the managing partner of his own firm, his clients other than Mr. Depp, and offers legal services to other clients. Ms. Heard presented no evidence that Mr. Depp was personally involved in directing or making the Waldman statements. In fact, the uncontroverted evidence was that Mr. Depp never saw the Waldman statements prior to seeing Ms. Heard's counterclaim in August 2020. Accordingly, the premise of Ms. Heard's counterclaim is that Mr. Depp is liable for the Waldman statements for no other reason than Mr. Waldman is his attorney. No one appears to dispute that Mr. Waldman did not act in any capacity for Mr. Depp other than his attorney. As Mr. Depp's attorney, Mr. Waldman should be considered an independent contractor whose torturous activity, if any, cannot be imputed to Mr. Depp without some other proof or direction or control. The uncontributed evidence established that Mr. Waldman was only an independent contractor for Mr. Depp. As a matter of law, therefore, Ms. Heard cannot hold Mr. Depp liable for any of the Waldman statements, and the trial court erred in denying Mr. Depp's motion to strike the counterclaim. And this is what many of the law tubers think are his strongest point in his appeal, and he may win on that. Ms. Heard presented no evidence of Mr. Waldman's actual malice. Even if the court were to conclude that Mr. Depp could be held liable for Mr. Waldman's allegedly torturous conduct, the trial court nonetheless erred in denying Mr. Depp's motion for summary judgment and motion to strike because Ms. Heard failed to present evidence to establish one of the required elements of defamation. Remember, he asked the motion to strike was after her case was presented, remember? Specifically, Ms. Heard failed to present evidence that Mr. Waldman acted with actual malice when he made the April 27 statements. As noted above, Ms. Heard chose to pursue a theory of vicarious liability against Mr. Depp at trial. She did not ask the jury to find that Mr. Depp was directly involved in making the Wallman statements, nor did she present any evidence that would permit that conclusion. Vicarious liability is liability for the tort of another person. The crux of respondeat superior. Liability is a finding that the employee was negligent. A vicarious claim, therefore, cannot proceed against an employer or principal absent as showing that the agent or employee committed a tort. Vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a vicarious liability claim against an employer without first proving that the employee committed a tort within the scope of his employment. If the agent cannot be held liable, neither can the principal, because there is nothing to impute. As a natural consequence, it is well settled in Virginia that where master and servant are sued together in a tort and the master's liability, if any, is solely dependent on the servant's conduct, a verdict for the servant necessarily exonerates the master. Well, I can only think is if they found the employee driving that truck, if he had been drinking, then the blame would totally be on the driver and not the company. That would be my layman's guess. Because a principal cannot be vicariously liable for his agent's tort unless the agent committed all elements of tort in the first place, Mr. Depp cannot be vicariously liable for Mr. Wallman's alleged tort unless Ms. Heard carried her burden of proving that Mr. Wallman committed every element of defamation, publication, an actionable statement, with the requisite intent. With respect to the requisite intent, a plaintiff who is a public figure such as Ms. Heard must prove that a false and defamatory statement was made with actual knowledge that it was false, or with reckless disregard of whether it was false or not. Now, I think this is a strong point because he actually made a claim. Adam made a claim to the LAPD to have her investigated for perjury. I mean, he went that far to file it in his name. I don't think he filed it under Johnny's name based on the evidence he collected. So if he felt that the statements he made were true, then it's not with actual malice. In order to establish actual malice, a plaintiff must demonstrate by clear and convincing evidence that the defendant realized that his statement was false or that he subjectively entertained serious doubt as to the truth of his statement. Importantly, actual malice is a subjective standard that examines the actual beliefs of the person publishing the defamatory statement at issue. Consequently, actual malice is not measured by whether a reasonable, prudent man would have published or would have investigated before publishing. Rather, there must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication. Adam did not entertain serious doubts, and he presented that in his testimony. The evidence must establish that the defendant had a high degree of awareness of probable falsity. And the footnote says nobody's disputing Ms. Heard's a public figure who must meet the actual malice standard, as she's a well-known actress whose activities are widely reported in the media, including the very Daily Mail articles that form the basis of her counterclaim. Indeed, Ms. Heard's proposed jury instruction regarding Ms. Heard's counterclaim, which were ultimately given without objection or appeal by Ms. Heard, set forth the actual malice standard. So the jury was instructed they had to find actual malice because she's a public figure. Thus, for instance, a mere failure to reasonably investigate the truth of one's words is not enough to establish actual malice because it does not establish subjective knowledge of falsity. Indeed, in the context of actual malice inquiry, a duty to investigate the accuracy of one's statements does not arise until the publisher of those statements has a high degree of subjective awareness of their probable falsity. Thus, to succeed on her defamation claim against Mr. Depp, Ms. Heard was required to establish by clear and convincing evidence that Mr. Wallman made the Wallman statements. He either knew they were false or he subjectively had a high degree of awareness that they were probably false. Clear and convincing evidence is that measure of a degree of proof which will produce in the mind of the trier of fact a firm belief or conviction as to allegations sought to be established. And this was the same for Johnny's claim against Amber. All of the statements in the op-ed, the jury found clear and convincing evidence to the measure of the proof in their mind that she had lied. Here, again, it's a higher standard. Now, in a criminal case, they have to do beyond reasonable doubt. A standard civil case would be more likely than not, 51%. And that's pretty much what happened in the UK. On review, appellate courts must exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. Ms. Heard presented no evidence, much less clear and convincing evidence, that Mr. Waldman made the April 27th statement with actual malice. Indeed, with respect to the April 27th Waldman statement, Ms. Heard presented no evidence regarding whether Mr. Waldman believed his statements to be true or false. And I think Mr. Waldman presented evidence in his testimony that he believed they were true, to the extent he actually filed a perjury claim. All evidence adduced at trial pertaining to Mr. Waldman's state of mind when he made the Waldman statements shows that Mr. Waldman believed these statements were true. Mr. Waldman testified at length, for example, about why he believed that Ms. Heard's allegations of abuse were false, citing testimony from multiple witnesses that contradicted Ms. Heard's account of events, including discrepancies in Ms. Heard's own story. In fact, Mr. Waldman testified that he filed a claim with the LAPD against Ms. Heard for perjury due to her claims that Mr. Depp abused her, and that he presented them with information that he believed established her perjury. Since Ms. Heard presented no evidence that would permit the jury to find by clear and convincing evidence that Mr. Waldman subjectively knew these statements were actually or probably false, the trial court erred in denying Mr. Depp's motion to strike the evidence, and the judgment in Ms. Heard's favor on the April 27th Waldman statements must be reversed. Ms. Heard's counsel, this is a footnote, did ask whether Mr. Waldman relied on information from Mr. Depp in making the statement. Mr. Depp's counsel asserted the attorney-client privilege and instructed Mr. Waldman not to answer, since the question directly invaded attorney-client communications. Ms. Heard did not move to compel a further response, nor could she plausibly have prevailed had she done so. Nor can any, this is important, nor can any inference be drawn from an objections and instructions not to answer. The jury was specifically instructed not to draw any inference from the assertion of an objection or instruction not to answer. Another instruction that is not the subject of Ms. Heard's appeal, and of course no adverse inference arises from the mere assertion of client-attorney privilege. And this is one of the things the law tubers were so upset with. They didn't understand why Judge Ascarati allowed this to go on and on and on in front of the jury. No adverse inference shall arise from invocation of the attorney-client or work product privilege. It's very hard to unhear things. As much as you're told you're not allowed to take any inferences from this, it's very hard to unhear it over and over and over again. In context, the Waldman statements are not actionable. Even if the court believed that Mr. Depp should be liable for Mr. Waldman's statements, Ms. Heard's counterclaim for defamation is still fundamentally defective because, read in context, the April 27th Waldman statement is not an actual statement of fact. The trial court thus erred in not granting Mr. Depp's motion for summary judgment and motion to strike the evidence. I need a quick drink, guys, here. It is tea time. Pure expressions of opinion not amounting to fighting words cannot form a basis of action for defamation. The First Amendment to the Federal Constitution and Article 1, Section 12 of the Constitution of Virginia protect the right of people to teach, preach, write, or speak any such opinion, however ill-founded, without inhibition by actions for libel or slander. There is no Constitution value in false statements of fact. Thus, in an action for defamation, a court must resolve as a threshold matter whether an alleged defamatory statement is one of fact or opinion. And this is going to be pretty much the same thing that Amber's going to argue about her op-ed, that it was opinion and not fact. The statement of fact is one with a provable false factual connotation, or which can reasonably be interpreted as stating actual facts about a person. Well, of course, what was already argued, now that I've mentioned it in Amber's op-ed, was the statement 2 years ago I became. So that pretty much stated her whole op-ed, that her experience she was writing about was 2 years ago when I accused. However, even a provably false statement is not actionable if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. And Amber would have been. She was speaking 2.5 years ago, exactly what she experienced.
I found this on the web for conjecture or...
Leave me alone. I don't need your help today. Importantly, in assessing whether allegedly defamatory words are fact or opinion, a court must examine them in context, with the aim being to interpret them as other people would understand them and according to the sense in which they appear to have been used. In the totality of the circumstances, thus, in considering whether a statement's audience would understand it as a statement of fact or opinion, courts consider such factors as the forum in which the allegedly defamatory statements were uttered, and whether an audience familiar with the forum would expect to hear an opinion. If a statement is made in a forum in which a reader would be likely to recognize that the critiques represent the highly subjective opinions of the author and relates to inherently ambiguous subject matter about which reasonable minds could draw different conclusions, then the general context in which the statements were made negates the impression that they imply a false assertion of fact. Courts also consider the degree to which the statement's audience is familiar with the underlying facts and therefore able to assess the defamatory statements for themselves. Well, that goes back to the op-ed. The underlying facts were 2 years ago, I became. So they probably didn't make a judgment for themselves when reading her op-ed. They probably took it at face value. Interesting. Concluding that statements were opinion when made to reporters who were familiar with the long-running dispute among the parties and knowledgeable of the underlying facts and therefore understood that the defendant was presenting his own opinion. In addition, courts consider whether the statements were made in the context of a debate or controversy, because statements made in the heat of a debate are more likely to be understood by their audience as expressions of opinion, drawing a distinction between the language of controversy and the language of defamation. Well, that makes sense because the reporters have been covering this for a long time, and the very, very long articles included a lot of the history of what got us here. The Daily Mail was known for the timelines at the bottom of their articles. They presented both sides like a debate, and they filled in their own opinions and conjectures in the rest of the article, in my opinion. That's how I read it. Courts also consider the identity of the speaker and whether the speaker's biases are known and disclosed to the audience. The most unsophisticated recipient of such a claim, made by one competitor against another, could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias. Well, obviously, her lawyer, Robbie Kaplan, wasn't going to say, I don't believe Amber, so I'm just representing her for the money. I mean, I'm not saying that's truth, but I'm saying, of course, the lawyer speaking on behalf of their client is going to speak biased to them. Further, courts can consider whether the speaker claims to have personal knowledge or is merely drawing inferences about events he does not claim to have witnessed. No liability was there, no claim to firsthand knowledge of facts, and the context and tenor of the article thus suggests that it reflects the writer's subjective and speculative supposition. Sorry, guys, supposition. So here's the quote. We've already read it. When read in isolation, this could arguably be interpreted as a factual statement sufficient to state a claim for defamation. When viewed in context, however, it is a non-actual opinion. Importantly, the April 27 Waldman statement is presented as a statement by a lawyer in the context of litigation and necessarily represents only one side of a heated debate. Further, it was made to a reporter who presented quotes from both sides of the debate and was necessarily aware that the facts were hotly disputed. Indeed, the April 27th article quotes Ms. Heard's attorney referring to Mr. Waldman's statements as fantasies. Mr. Waldman never claims personal knowledge of what happened on May 21 at Mr. Depp's and Ms. Heard's shared penthouses, and no one disputes this. Rather, it is clear from the April 27th article that Mr. Waldman was speaking as a legal advocate and offering his own interpretation of disputed evidence. The April 27 Waldman statement is, thus, most reasonably understood as an attorney's interpretation of the conflicting allegations and evidence in a he said, she said dispute, and as such cannot be defamatory. No liability where there was no claim to firsthand knowledge of facts, and the context and tenor of the article thus suggests that it reflects the writer's subjective and speculative position. They're pulling a lot of legal sightings here, which they have to do. Writers must be given some leeway to offer rational interpretation of ambiguous sources. No liability in defamation for statements by an attorney that were a subjective assessment of evidence which could not have been objectively characterized as true or false at the time, as it depended largely on his own perspective and assessment of the weight of the available evidence. No liability for defamation for accusing a plaintiff of lying when a reasonable person would have perceived the accusation as pure opinion based on the defendant's subjective understanding of the underlying scenario. In context, it is clear that each of the Wallman statements, including the April 27 Wallman statement, reflects a subjective view and interpretation, a theory, conjecture, or surmise, so as to be non-actionable opinion. Mr. Wallman indisputably had no personal knowledge of what happened at the Eastern Columbia building on May 21, as set forth in section of the supra. The evidence presented at trial shows that Mr. Wallman subjectively believed, based on evidence that he collected and reviewed, that Ms. Heard's claims of abuse against Mr. Depp were false. And so in the April 27 Wallman statement, Mr. Wallman was merely drawing inferences and speculating based on the evidence available to him what must have happened on May 21. This recent good faith interpretation of the evidence cannot be defamatory. The trial court accordingly erred in denying Mr. Depp's motion for summary judgment and motion to strike. So in their footnote, this analysis holds true of all the Wallman statements. So they're saying that the jury got it right on two of them, understanding they were opinions. The analysis holds true of all the Wallman statements, as each was made to reporters who acknowledged and described the clash of two fundamentally different versions of events from Mr. Depp and Ms. Heard. Each acknowledged Mr. Wallman's bias and status as an attorney for Mr. Depp, and each ultimately expressed Mr. Wallman's own interpretation of the weight, reliability, and credibility of conflicting evidence about which he did not claim to and did not have direct firsthand knowledge to. So we have the standard review on the proposed instruction, jury instructions 22, 23, and 24. I know there was a verbal discussion in court. We've never seen a printout of what they were trying to get put in. Jury instructions are reviewed under an abuse of discretion standards. In reviewing a trial court's decision to refuse jury instructions, the evidence is viewed in the light most favorable to the proponent of the instructions. That would be Mr. Depp. Whether the content of the instruction is an accurate statement of the relevant legal principles is the question of law that, like all questions of law, is subject to review de novo. In a proffered instruction finds any support in credible evidence, its refusal is reversible error. So if this is de novo again, it sounds like the appeal judges have a right to look at those jury instructions 22, 23, 24 by their own interpretation and not how Judge Ascarati. Would they have interpreted it the same? If they interpret it different, then it would support incredible evidence, the refusal. If they found that those should have been included, it's a reversible error. Evidence was presented from which the jury could have found that Mr. Wallman was an independent contractor. At trial, Mr. Depp proposed jury instruction number 22. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way he brings about the result. If you find that Mr. Wallman was acting on Mr. Depp's behalf, but was not subject to Mr. Depp's control as to the manner, method, and or means by which Mr. Wallman worked, you must find that Mr. Wallman was an independent contractor. An outside lawyer retained by a client in connection with litigation is an independent contractor. Would be his number 23. Here it is. Their instruction is, if you find an outside lawyer retained by a client in connection with litigation is an independent contractor. Number 24, a person who hires an independent contractor is not liable for the independent contractor's actions. If you find that Mr. Wallman was an independent contractor of Mr. Depp instead of an employee, you may not find Mr. Depp liable for Mr. Wallman's conduct. The court denied these instructions, and if I remember right, they strictly went forward with the finding of agency. Did you find that Mr. Wallman was acting on behalf of Depp? Then he's an agent, and therefore he's liable. Don't quote me on that, but that's what I'm thinking. I remember just seeing the word agency over and over. Mr. Depp incorporates by this reference and will not repeat at length the arguments set forth above regarding Mr. Waldman's status as an independent contractor. In sum, since the evidence supports a finding that Mr. Waldman was an independent contractor, his allegedly torturous conduct cannot be imputed to Mr. Depp. Absent evidence of additional involvement by Mr. Depp is making a defamatory statement which was not present at trial. The evidence at trial established that Mr. Waldman represented Mr. Depp solely as an attorney in various litigation matters, but in no other capacity. As such, the court should adopt the majority position of other jurisdictions that an attorney representing a client in litigation is an independent contractor. Even if the court declines to adopt a per se rule, evidence was presented from which the jury could reasonably have found that Mr. Waldman was an independent contractor, not subject to his client's control in the details of his work. For instance, Mr. Waldman testified, that he's the owner and managing member of his own law firm, that he offers legal services to clients, and that Mr. Depp is not his only client. Accordingly, the trial court erred in rejecting jury instruction number 22, 23, and 24 because a reasonable trier of fact could have concluded, based on the evidence, that Mr. Waldman was an independent contractor and thus Mr. Depp could not be vicariously liable for Mr. Waldman's statements. The court erred in excluding the full articles containing the Waldman statements. And I found this one interesting because when they presented Amber Heard's op-ed, not only did the entire op-ed go in as an exhibit, but I remember Ben Rottenborn actually reading the op-ed. And evidence came out later from the ACU that they were the ones actually drafting. So they weren't drafting several versions of that op-ed. So not all those words in the op-ed were Amber Heard's, just as in an article, a reporter adds their own words. Because I was trying to balance in my head why the entire op-ed had to be considered in context, presuming because she was the author of it. Whereas these articles, Mr. Waldman's not the article of the entire article, and therefore they removed everybody's words except, well, they even removed some of his. So they took that out of context too. Anyway, get back to the document. The trial court erred in excluding the full articles containing the Waldman's statements. A trial court's decision to admit or exclude evidence is reviewed under an abuse of discretion standard. At trial, the unredacted articles provided necessary context. I'm going to show you these just so you can have this in your mind when you're hearing what I'm saying now. Here we go. And this was on the screen. It was a video of the stream trial, and this was shown to the screen. I know it's very blurry, but what's important is these are the statements they're reading. They blacked everything out. And here is the Amber Heard and her friends and essay allegations are use of both a sword and a shield. Some of her SV hoax. All right. So this was used. I know you can't read it, but you can see the big black square. Here it is. The rest of his statement here, everything. This is how it was given to the jury. I just want you to see this. This is the article. Now, she submitted the entire articles unredacted as an attachment to her counterclaim. Judge Ascarati ordered and agreed that all of the article would be redacted except for, here's just a little bit of his quotes. Amber and friends spilled a little wine. See, that's the quote. Everything else is blacked out. No context whatsoever. This is one article. I think this is the next one. Here it is again. Everything's blacked out in the article. Everything's blacked out. All they got is Depp's attorney Waldman said, blackout, reached the beginning of the end of Miss Heard's abuse hoax against Johnny Depp. That's all the jury got to see. So we go back to his reading. So you have that in your mind of what the jury is deciding on these statements. At trial, Mr. Depp sought to introduce unredacted copies of 3 Daily Mail articles containing each of the 3 Waldman statements, the Daily Mail articles. The trial court excluded the Daily Mail articles as hearsay, admitting only copies that had everything but the Waldman statements redacted. The court's apparent reasoning was that the Daily Mail articles were written by reporters, not Mr. Waldman. Oh, I guess that. So the context that matters is the context in which Mr. Waldman made the statements to the reporters, not the context in which the statements appear in the articles. As set forth in section 4A4 supra, in assessing whether a statement is actionable for defamation, context is paramount. In fact, Ben Rottenberg really pushed that when he read the whole article. You have to read it in context. And that was the order that was given. The jury instruction was given about the op-ed. You had to consider the 3 statements in context of her article. And they still said, yeah, 2 years ago, everything she said was referring to her experience with her claims against Depp. While the context in which Mr. Waldman made the original statement to reporters is relevant, the contents of the articles are also relevant. For instance, the full articles in which the Waldman statements appeared are relevant to how the reporters and ultimately the readers understood Mr. Waldman's statements, as presenting one side's interpretation of evidence gathered in a hotly contested litigation. Further, the April 27th article includes additional quotes from Mr. Waldman that put his April 27th statement in context. Yeah, I just said that he's made other statements that they also redacted, identifying the evidence he is interpreting. But even this didn't have the desired effect, because 2 domestic abuse trained LAPD police would later provide a pair of sworn depositions saying they saw no evidence of a crime. The full articles in which the Waldman statements appeared are relevant to assess what, if any, damages Ms. Heard purportedly sustained from them. In assessing whether Ms. Heard suffered any damages from the Waldman statements, the jury should have been able to consider that the Waldman statements were buried in the bottom of salacious tabloid articles and surrounded by substantial additional commentary about Depp and Heard, little of which was flattering to either of them. The trial court erred in excluding the articles in their full context. Conclusion, I'm sure you're happy I'm gotten to that. The court should reverse the judgment on Ms. Heard's counterclaim as to the April 27 Waldman statement, but should otherwise affirm the judgment in Mr. Depp's favor. So they want to make sure that he doesn't. So this is all that. What else have I got? Okay. So just to give you an update on that now, I have to look at my notes again. Hold on. Schedule of appeals. So Johnny has filed his now on November 2nd. She has 30 days. So December 2nd, Amber has to file a brief to respond to this. She's going to complain about, I'm sure she's going to bring up that Adams Pro Hac Vici was revoked and try and put him in very bad light. I'm guessing, I don't want to put anything out that they can use if they hadn't thought about it. So I'm not putting it out. But she's due December 2nd, unless for some reason she tries to get an extension. Do you think she will? Well, that's what she usually does, right? I'm really busy doing my own appeal. Judges said, can you give me more time to answer this? Right? So that's what we have. So she is due to answer Johnny's appeal brief on December 2nd. And then December 16th, assuming she doesn't get an extension, assuming from whatever date she files it, it's 14 days later. So if she were crazily enough to file it November 30th, it would be 14 days from that. But as of right now, she's due December 2nd. All right. So DUI guy on Twitter was nice enough to share with me some documents because I was traveling. So he gained acquired some documents from Amber Heard's entire filing so far in Virginia. And here, I just thought you'd be interested. On August 15, 2022, Amber Heard did file that Elaine Charles Braderhoff and Adam Nadelhoft and David Murphy were withdrawing as co-counsel for the appeal. And I find this really interesting. And one of the reasons I wanted to bring it up, she's currently and will continue to be on counsel record with Ben Rottenborn and his firm, Woods and Rogers. Jay Brown, the law firm from Ballard Spahr, is joining her. And she feels she's sufficiently represented by counsel. Therefore, she wants them to be removed ongoing further in the appeal. Let me get a drink because I'm getting all excited here. To be very clear, they're making it clear, they are no longer involved in the appeal. And it's so ordered. It was so ordered eventually. Consent order granting withdrawal motion. Now, why is this a big deal for me? I've been covering the lawsuits for the insurance lawsuits. And one of the things Amber Heard is claiming that she feels if they don't do a stay in the New York Marine versus Travelers, or even, New York Marine versus Amber Heard, and even the other one, Travelers versus New York Marine. She wants to stay because she feels that this will, because they're going to depose her lawyers, that it could impact her appeal, her confidentiality in her appeal. Well, so far we know by the documents that have been filed, they are going to depose her personal lawyer. They're going to, who is not part of this litigation any place, is not on the list anywhere of her appeal counsel. They're going to depose Robbie Kaplan. They're going to depose Cameron McElvoy's office. And they're going to depose Elaine Bradehoff. And none of those people, none of those attorneys are involved with this appeal going forward. So I'm not sure how they need to stay those insurance lawsuits that they might impact the appeal, because those lawyers with privilege have nothing to do with this. And they'd be under a protective order anyway. So anyway, that's what else is this? We also had another filing. There's like 122 pages here. I just want to go to one more page. I don't want to blind you all, so let me get down there to it. They also had some crazy person file on Amber's behalf, and DUI guy filed. He covered that, and I'll be nice. I want to put that link in the bottom to thank him for giving me these documents. Okay. Can I make this bigger for you? Appellant's motion for extension of time to file her opening brief and for limit to file to exceed the page limit. Now, my understanding, there's a 50-page limit, but I thought there was also a word limit. And I don't think it's mentioned here. Appellant Amber Laura Heard respectfully files this motion for a 28-day extension of the deadline to file her opening brief. In addition, Ms. Heard seeks leave pursuant to all these rules to file an opening brief that exceeds the 50-page limit by 10 pages. In support of this motion, Ms. Heard states the following. Appellant filed her designation of assignments of error October 11th, 2022. Appellant's opening brief is currently due November 2nd. Appellant seeks an additional 28 days to prepare an opening brief. Good cause exists for this extension because of the complexity of this matter, the volume of the record, and the fact that the appellant has recently retained new counsel to represent her on appeal. Additionally, appellant seeks leave to file an opening brief of 60 pages because of the complexity of this matter, the volume of the record, and the length of the trial. Appellant believes she cannot adequately address all of her assignments of errors in 50 pages, and therefore good cause exists for a 10-page extension. Now remember, she claimed 16 assignments of error. That doesn't mean she's going to have 16 assignments of error when she finally submits her brief. She was just making sure she reserved those. And then with new counsel, they're going to figure out what they're really going to do. Undersigned counsel asked Appellee's counsel for Appellee's consent to these two requests. Appellee opposes both requests. So Johnny Depp's team said, no, hell no. We're appealing too. We met the 50-page limit and we met the deadline. Wherefore, appellant respectfully requests that this court grant a 28-day extension until November 30th. Appellant's deadline to file an opening brief, grant leave to file a brief that exists at 50-page limit by 10 pages. We're told of 60 pages, and grant any other relief the court deems just and proper. Now, there's no mention of number of words or number of characters, so I saw that a lot. That may be a rule. It may not be what they're using standard today. I don't know, but it seems like they're really all about the page limit. So she wants a 28-day extension until November 30th. Now, we have a big holiday next week. Thursday's the holiday, Thanksgiving. I think the courts are only closed for Thursday, but it's not unusual for a lot of people to be on vacation. Judges could take on vacation. So she was trying to get it past the holiday week. These are her new lawyers, Ben's office and Brown's office, Ballard Spar. And I'm mentioning that to show that none of the other attorneys that are being taken for depositions in the insurance lawsuits are still involved in the appeal. So Johnny opposed this, of course. Appellate Johnny Depp, buying through his undersigned counsel, hereby opposes Amber Heard's motion for an extension of time. Appellant has stated no good cause for any delay of her opening brief, certainly not for an additional 28 days. Her proffer that she recently retained new counsel to represent her appeal is inaccurate. In fact, 3 of her counsel in this appeal, Rottenberg, McCafferty, and Stemland, all of Wood Rogers, represented her at trial in this case. Moreover, appellant's new co-counsel at Ballard Spar, her fourth set of lead counsel, entered his appearance in court August 15th, more than 2 months ago. Thus, the joinder of co-counsel does not constitute good cause for any continuance, nor does appellant cite any particulars to support her contention that the complexity of this matter or the volume of the record somehow constitute good cause. Simply making a conclusory assertion does not meet the standard, much less justify a month-long extension in the case that already has been litigated on for more than 3 years. So 3 years this case has been litigated, and I love the shade that they throw. More than 2 months ago. No, this is the fourth set of lead counsel, not just the fourth set of counsel, the fourth set of lead counsel that they had to throw shade and say, this is what Amber does. She keeps changing over her attorneys. Now she's doing it and asking for more time. Lots of shade there. Granting appellant Heard's extension would further delay the process and perforce complicate and extend the entire briefing and argument schedule. Appellee Depp is not, for example, requesting any extension for the briefing schedule on the one aspect of the trial he lost is appealing. Were the court to grant Amber's motion, the two appeals would be on different tracks. And I can understand how that could be confusing because the judges are looking at the same information, pretty much the same. They're having to pull out the court records and stuff. And he's furthering, appellant Heard changed her lead counsel 3 times during the proceedings below. 2, to the extent the court is nevertheless inclined to grant her request of extension of time, the appellee respectfully submits that it should not. Appellee would request that the court also extend time to file his brief. So Depp is saying, hey, if you're going to give her time to file her brief and it's so complicated and it's so twisted and it has so much information that you're willing to give her more time, then you should give us more time to reply by the same amount of days. Or no, he wants it by 28 days. She wants. Is that the same amount of time she wants? 28 days. So he's saying if you're going to give her 28 days more, I want 28 days more. The court should deny appellant's motion for an extension of the page limit. As with her motion to extend the deadline of filing her opening brief, Heard relies only on a conclusory statement. The complexity of this matter, the volume of the record, and the length of the trial somehow show that she cannot adequately address all her assignments of error in 50 pages. Indeed, appellant makes no proffer whatsoever as to why her appeal presents particularly complex matters or how the volume of this record or the length of the trial would somehow constitute good cause for a departure from the court's standard rules for page limits. Moreover, the court should decline to increase the page limit because doing so would perversely reward appellant for taking a frivolous scattershot approach to her assignments of error, rather than seek to identify and focus on a few genuine issues. Oh, so much shade. So much shade. Ms. Heard filed a laundry list of 16 broad assignments of error, many of which are mutually contradictory. Indulging appellant with 10 more pages would only unfairly prejudice Depp, who would have to respond to Heard's extraneous arguments, but would also encourage future appellants to take similar scattershot approach. To the extent the court is nevertheless inclined to grant appellant the requested extension of the page limit, and appellee respectfully submits that it should not, appellee would request that the court also extend the page limit of his opposition for 10 pages as well. I think my mouth's getting too dry. So Depp is saying, hey, if you're going to give her 28 days more, you're going to give her 10 pages more for her brief, we want 28 days more and 10 pages more to respond. Let's be fair. So now the court appeals filed that you're going to be doing everything in electronic. Don't file all these papers. On October 13, 2022, came appellant by counsel and filed a motion praying that the court grant her an extension of time to file an opening brief and permit her to file an opening brief that exceeds 50-page limit by 10 pages. Thereupon came the appellee for counsel and filed a response in opposition. Upon consideration whereof, an extension of time is granted to the appellant until November 23rd, that's just next week, to file the opening brief, and is granted her file for 55 pages. So she's getting an extra 5 pages. Again, no mention of characters or number of words. It's strictly pages. And she didn't get her full 28 days. She got November 23rd. So you can get her November 30th, and she's only getting 5 more pages. So Depp unopposed motion for extension of time to file opening brief. So Johnny Depp now is filed through his counsel. In addition, pursuant to all these rules, he seeks now, after this order has just been done, he now seeks to leave file an opposition brief that exceeds the 50. He wants the same thing, 50 pages by 5 pages. In further support of this motion, Mr. Depp states the follows. On October 18th, the Honorable Court entered an order granting Heard a 3-week extension in the filing of her opening brief until November 23rd and granted her leave of 55 pages. Depp immediately inquired whether, consistent with the order, Heard would agree to motion by Depp to extend his deadline for the filing. In opposition of so he says, we've already talked to Heard's counsel, and we want the same thing. We want an extension of the same amount of days and an extension of the same number of pages. Heard advised today that she would not oppose this motion. So the court should grant this unopposed motion because fairness mitigates or militates toward allowing Depp the same length of extension of the deadline if it's granted to Heard. Mr. Depp should be allowed to file the same number of pages. So wherefore, and this is where it gets specific because Depp has laid out specific dates. Depp respectfully requests that this honorable court grant him a 3-week extension of his deadline to file an opposition brief from December 23rd until, if she had turned it in on the deadline. Okay, let me say that again. December 23rd would be the 30 days from November 23rd, right? And they want the same extra days that they don't have to respond to January 13th, which I think is too huge to do because there's so much going on with Christmas. And grant him leave to file an opposition brief of 55 pages. Well, this becomes an issue because they're saying specific dates, and you'll see why I say that. The court says no, but this court will acknowledge receipt of your motion of extended time to file an appellee's brief and leave to exceed the page limit in the above referenced case. However, Amber Heard's brief is not due to be filed in the office until 30 days after the filing of, Depp's brief is not due to be filed in the office of the clerk until 30 days after the filing of the opening brief. The appellant has not yet filed the opening brief in this case. Thus, no due date has been established. So in other words, they gave her till November 23rd, but let's say she were to file it November 20th. Well, 30 days from November 20th would be December 20th. So that's the date if they were going to give them the extension, that's the date they'll count the 28 days off of. So that's why they can't do this at this time. Accordingly, the court will not take any action on your motion. They're not denying it. They're just saying, I can't take action on it. Please note that once Heard files her brief, the due date for the filing of the appellate's brief will be established. If at that time you determine that you need additional time and pages to respond to such brief, you can file a motion on it. So since it was unopposed, I'm sure that's what they're going to do. Yeah, I'm sure that's what's going to end up happening because the both sides unopposed it. It's just that they can't give you specific dates because the dates count off of when Heard finally files her appeal. So now they're on different tracks. Whether that's good or bad, it gives Depp more time to deal with. You know, they're doing their due diligence too. They're already researching those 16 assignments of error that Amber claimed, even if she doesn't follow through with them. And it's scattershot. Boy, they really had a lot of shade in this. Anyway, I wanted to get this memorialized. I want to get this done. So there's a lot happening next week. We have on November 21st, we're supposed to have a hearing for the consolidation and if they're going to go forward, if they're going to stay. This is in the insurance lawsuits because they consolidated them. So there's supposed to be a hearing of what's coming next. Are we moving forward depositions? Amber Heard threatened that she was going to file dismissal. Amber Heard threatened that they had the wrong jurisdiction because she was stateless. I'll touch on that. November 21st, Amber Heard's answer is due in the lawsuit unless she files a stay or dismissal or anything. And November 23rd, Amber's brief is due. I'm also covering Ari Jacobs versus Taylor Lorenz and New York Times. She filed an amended claim against her, and their answer is due November 18th. So there's a lot coming up. Yeah, let me see if I can show you what I just saw. I think I can. that was filed. Let's see if I can show this. Oh, I have to update it. Bear with me, guys, because this is being good. Since I did put it out on Twitter, we'll get it updated here. So let's see, October 31st. Where is the newest filing? Here it is. Okay. So let's present this since we're here. This is the newest filing for Amber Heard's courts. Now I'm going to see if I can possibly make this bigger for you guys. Yes, I can. All right. So well, first of all, I can jump ahead and say the copyright lawsuit for Depp versus Bruce Jackson, the party has all arrived. So we have Prohack Vici, we have Wayne Dennison, we have Camille, we have Ben Chu, we have Stephanie Kalnin. So he's got all his band there to join in representing him. New York Marine General Insurance versus Amber Heard. Now remember, these have been consolidated, the insurance lawsuits for pre-trial only, but not everything is being posted to both cases. So there was a scheduling notice. Amber Heard had claimed in their, they had what was going on, everyone's positions. And Amber Heard was trying to claim that you don't have jurisdiction over me. You don't have diversity of jurisdiction, meaning multiple states. The parties that come from multiple states, because I'm not from any state anymore. I'm stateless. I don't have a resident in the United States. I've left one. And they cited a case specifically where the person claiming that they were no longer a resident or were stateless from the U.S. had established a place to live internationally for many years, a domicile. So the case doesn't really match her because she doesn't have any proof of domicile anywhere else. I mean, she rented a place in Spain. She was later seen in the UK again. I don't think a recent lease from an Airbnb is something that can establish your domicility, your domicile. You have to have not just rent a place like you would on vacation. You have to have tax records, some kind of insurance, driver's. I mean, there's a lot more than just saying I rented an Airbnb. I'm not saying that's what it is, for a couple months. So therefore I'm no longer a U.S. resident. Now, I know, she had a house that she sold, but if she wasn't living in that house, I don't know. But anyway, back to this. So a scheduling notice. So she was going to claim that they had the wrong jurisdiction, and she was also going to ask for a stay. And she talked about filing for a dismissal. So they were supposed to have a hearing on November 14th. The informal discovery conference, these things are, these are pretty important. Even though it says informal, these IDCs are really important. Previously set for Monday, November 14th at 1 p.m. is taken off the calendar. Parties have informed the court that they have resolved their dispute and will not need a conference with the judge. There is no PDF document associated. So I think my speculation, and Andrea Burkhart put out the same tweet, that she realized she couldn't prove her non-jurisdiction, that they didn't have diversity, that she was stateless. I don't think she could prove that to the standards required for domicile, etc. So I think they just dropped that. So now we're waiting to see if she's going to file a motion to dismiss for some other reason, or to stay the action until after the appeal is complete. Because if she wins her appeal, then it's not a intentional tort. So that's that. So that's where we're up to date now. Lots coming down next week. Of course, it's a holiday week. Family here, lots to do. I'll do my best. I have some videos I've made that I'll put out for next week, but I'm not sure I can jump on right away and report on everything. Although, of course, I want to get Amber's response brief, her appeal brief, her official appeal brief. We want to present that. So thank you guys for watching. I really appreciate your support. Like, subscribe, share. As usual, I really need that help. Again, I'm doing a lot of, I'm doing a lot of videos that are predating the trial, what led up to the trial, the battles for the trial, the unsealed documents, a lot of those documents that I'll be presenting I paid for. So I appreciate any help in my PayPal if you are so inclined. And again, thank you for watching and have a great weekend. Bye, everyone.